Hi, good afternoon, everyone. Welcome back to our series of webinars. This is the eighth one which we are bringing for you. And thank you so much for all the positive responses which we are getting from all the users and who are attending our webinars. That they're quite liking the way we are conducting the webinars and the format, more of our panel discussions rather than just a single point view. This time we have come back to you with a new subject on code on wages. While we proceed with the discussion on the code on wages, let me again, as I always say this, let me do the customary introduction once again. I am Jyant Kolhi, founder and CEO of Lawrbit. Uh, and Just a quick note about our Lawrbit. While I'm sure by now you know about us. Uh, Lawbit provides SaaS-based risk and compliance management solutions for enterprises globally. Our solutions are integrated with the global regulatory intelligence for almost 5,000 plus laws, a lakh plus compliance across different jurisdictions. Within India, it's around 60,000 plus compliances. You name a law, and we already have those mapped in the system. This solutions is meant for startups to the largest of the enterprises, having multi-country presence. And By now, we have served around 225 plus entities. We have a team of around 65 plus lawyers who are working behind the scene to provide you these services and bring it to you. And If you are using our compliance solutions, great. If you're not, feel free to get in touch with us. We would love to show you what we have built, and maybe we may have an opportunity to work together. Uh, with this, I would quickly jump on to our discussions for today. Actually, next slide, please. And also introduce you to our to my co-panelists today. Rather, these are the ones you will hear more today rather than me. Vaibhav Bhardwaj. Vaibhav is a partner in the IndusLaw based out of Delhi NCR, and he's part of their employment law, anti-bribery and anti-corruption practice. And he has been like he has almost like 17 years experience, if I'm not wrong, Vaibhav, in advising clients across various sectors, including financial services and retail in relation to structuring of workforce, social security. And Vaibhav, I think while you did not share with me, I think you recently got awarded as a leading lawyer in the employment law space. Congratulations for that. And
Thank
I'm
you so
sure
much, Jan.
I'm sure, Vaibhav, your inputs would add a lot of value to our friends here, and look forward to hear from you today. Uh, Joining also with us, Mr. Thirupathi Reddy. He's the AGM for Patra, India, which is again a global firm. I'm sure you all have heard of it. He specializes in compensation and benefits. And Tirupati is also a HR professional with 16 plus years of experience of working in the payroll and global HR compliance domain. Uh, Not just India, I think multiple countries, as you could see on the slide himself. Yeah, his understanding of the subject, whatever I've understood, from him, and in our various discussions, is very deeper. Even I'm sure if you have any questions, please feel free to ask him, whether it's related to understanding the various aspect of those various components, how deeper you can, actually on ground you could calculate it and ensure you are fully compliant with these laws and expectation from the regulators. I'm sure Tirupati's perspective and the practical experience would help us understanding the nitty-gritties pretty well. Welcome on, Tirupati. Thank you for joining us. And let's
Thank you,
let's
Jyant.
and let's okay yeah we okay For everyone's benefit, we are also going to record this particular session, and uh, We'll try and share the links with all of you. And if you want a copy, link to this recording, please drop in a line for our team on the chat groups. They will make sure that you receive a copy of those recordings as well. And as Ankita has mentioned, you can also subscribe to our YouTube channel as well. Now, coming on to wage codes, just a random thought which I was having in the morning. Um, Normally, we have picked up the laws in all our previous webinars, which were the hot topic, which were getting discussed at that point of time. Now suddenly I saw, the title itself, code, code on wages 2019. We're entering 2024, and we're talking about a code on wages 2019 still. And why is it such an old act still getting discussed? Because even if it's 2019, it's yet not, been operational. So we still are waiting for it to come in force. Uh, in this and why we have chosen this particular time of the year to discuss on this topic, because what as the political moments we are seeing, uh, we may see that this code may come in force in the upcoming year. While you ask me, Jayant, are you sure? I am not sure, because there were times, in fact, in the beginning of 2023 also, we were talking about these codes may become effective from April 23 onwards, but somehow the political decisions were changed. But as we are approaching a new year, and this is a election year, we may see the change in government, or I would say the new government getting formed. This code may come back into limelight at that point of time. Not just code on wages, but all other codes as well. So the perspective of doing these webinars at this point of time is be so that you all are be aware of what these codes are, and if a preparation is required at your end to be ready for these codes, I think we should utilize the next 3 months and get ourselves ready, because it may be a big surprise that from immediately after elections we may have to be compliant with these codes. So idea of getting it is that. And in this discussion today, we are going to talk about a basic understanding of the codes, the laws which are going to be subsumed in these codes, and the framework, overview, aims and objectives of codes of wages, rules, status and powers of state, because these are going to be playing a very important role. We'll talk about the status, which all states have already come up with their rules, where you can find the copy of those rules, understanding of very some key definitions, because they are going to play a very important role as well. Um, Employees obligation, while we're not talking about everything, but we are going to be talking about the key obligations as an employer, and some FAQs, and maybe we'll try and take a couple of questions which people have shared with us beforehand. And if time permits, we will also share these codes, these take another couple of questions from the user perspective as well. Now, I'm going to invite Vaibhav and Mr. Thirupathi to take it over from here, and let's get into the discussion.
Yep. Thank you, Jayant, for introduction of the labor codes, which we are like a relevant topic today. And before going to the topic, I just want to congratulate Vaibhav for his outstanding achievement, which is a great to hear. And I'm very happy that I'm like co-hosting with Vaibhav, who's a great legal aspirant. I can say that. Yep. And thank you for
thank you so much, Mr. Reddy.
Yeah. Thank you, and have all the best for your all other endeavors in the future. Yep. Coming back to the labor codes, which we are going to discuss now. So see, we are talking about labor codes. First thing we need to understand why there is a change in the labor code. So are we not having any labor code in the initial? Yes, we have the labor codes. So there is a need for the change because there are multiple things are involved in that one. Example, 62% of workforce who are casual workers are not getting the minimum wages. And if you see the labor ministry recently, or like maybe last 10 years back, they quoted that 33% of wage workers are paid less than the minimum wages, which is like minimum wages are again state wise it differs and it's too much complicated. So over the years there are many statutories or many labor codes are enacted for specific issues. But if you see, those are some of the laws are redundant and some of the multiplicity of labor laws are there. So because of all these issues, there is a need for the change in the labor code. So which is important for us, which is important both for employee as well as employer. If you see second National Commission on Labor Law in the month of June 2002, so they have recommended that so there is a need for the changes in our labor laws, and they are like giving the quite a bit of five kind of groups which are very much important for us. One is like industrial relations, and second one is for wages, and third one is for social security, and fourth one is safety, and fifth one is again working conditions of the employees. Based on all these things, and India has like consolidated different labor laws. If you see, there are like more than 100 state labor laws and nearly 40 central labor laws are there. So consolidating all those labor laws into four different kind of the labor laws, which is like taken a good decision to focusing on the improving the business as well as improving the conditions of the employees. So that's how it enacted like four focusing on four these labor codes. So if you see codes on wages, which we are going to discuss today, majorly focusing on taking care of laws related to wages and taking care of minimum wage for all the employees. And if you see, there are so much bias in the women and men in the previous years. So now focusing on the gender discrimination, eliminating of those kind of stuff. So is focusing on those are focusing on code on wages 2019. So coming back to the social security, which is again so if you see there are like almost like 8 acts or amalgamated into one, which is a code on social security. Those 8 acts. If you take ESIC and PF and maternity benefit, those kind of acts are amalgamated into one act and giving as a code on social security. Third one is again industrial relations code, which again talking about trade unions and taking care of industrial establishments and what are the industrial disputes and how we can resolve and how we can mitigate those kind of stuff, focusing more on those stuff. And if you see, those are like previously we have like three acts were there. One is Industrial Disputes Act and trade unions, and those stuff were amalgamated into one. Coming back to occupational safety health, and which is again so focusing more on the working hours and taking care of the employees welfare is a major focus, and leaves also major priority for us to focus on the providing the employee welfare and taking care of their family, also major focus on that one. So if you see, there are like 13 acts were there which are amalgamated into one, so which comes again into the occupational safety health and working conditions. Next slide. Shit. Okay, so there are like four laws were amalgamated into one, and which is like Minimum Wages Act 1948 and Payments of Wages Act 1936 and Payment of Bonus Act 1965 and Equal Remuneration Act 1976. So if you see, all those four were enacted long time back, and we need to have the additional input, and as per the inflation, if you take all other factors into consideration, so based on that, those are subsumed into one category and considered as a code on wages 2019. So this act was introduced in Lok Sabha in 2019, that is in July 23rd, and that act was passed on July 30th on 2019. And coming back to Rajya Sabha, it is on August 2nd. So they got the president confirm and assent on August, in the month of August 8, and on the same day Gazette has been passed for this code. So if you see this 2019, so it's almost like 4 years, and as Jyant was mentioning, so why we are talking about this now? So because so government has given a flexible time for all the states to come up with their versions or their views, because if you see when these acts are enacted and the government has consulted all the companies or establishments and talking about the state governments, and they have given all the drafts to them. And if you are coming back with the questions, they are ready to do the changes. They have taken enough time and they have given enough time for us to understand. And if you have any questions, they can we can reach out to them and those changes can be taken into effect. But if you see, there are, as Jayant mentioned, there are so many political factors and other things. That's why it was not into effect. So maybe we may foresee those changes in 2024. That's what the expectation. Okay, coming back to what is the major aim and objective of this code on wages, so which is like spread across 9 chapters and 69 sections. If you see previous earliest codes, there are 4 codes were there, right? So in that there are almost like 111 sections were there. It's like a little bigger version, I can say. If you see all the 4 things and consolidate into 69 sections and only 9 chapters, it's really, I can feel that it's an awesome and everyone will understand the basic requirement. What are the things to be changed? And major objective of this code is to make sure that timeliness of the payment for all the employees, including see there is no because previously if you see older versions there is a scheduled establishments were there. So now that was removed and including all the establishment as well as all the employees. So that is a major thing and everyone should get the wages on time. So that is a major focus for us. Coming back to the second point and where regulation of wages and bonus payments for all employees to see whether any sector, whether it is industry, trade, business, anything. So it is making sure that everyone should be included and they should get the wages. So that is the major focus. And third point is like so focusing on the equity. See, we'll all, if you see the current generation, so we are talking about gender equality and everything. So if you see still there is a scope for the improvement on those stuff, because in some cases, because if you see all these codes, why we are going into the new codes, because there was a gender discrimination and based on the some location, some geography, and if you are doing the same work, they are getting some different amount and you are getting some different wages or different salaries. To make sure that everyone is getting the same set of work, whoever is doing the same set of work, and if the skills and experience is same, so they should get the same kind of remuneration for whatever the work they are doing. So to make sure that to mitigate all the gender equality as well as the work thing, right? So for that purpose, this code is enabled and promoting the equity and labor welfare for creation of employment opportunities. So that's the major focus doing enacting this act. And coming back to the last one, or maybe I can say that one more thing, because see, if you see all other labelers are very cumbersome for us. So when we are doing this one, like there is no transparency and we have like so many other registers should be followed and there are so many other compliances. To ease of the compliance process, this code is like giving those solution for employers as well as employees. As if you say, if you take HRs, right, there's those people are very much struggling in finding out which is required for which kind of regulatory authority. So to mitigate and reducing those kind of compliance burden, so this code will enable those kind of purpose to solve those resolutions. And if you see, there is a change in the role of inspectors. Previously they used to only question all the establishments and regulatory authorities. Now they are like advising the company, stating that what we can do so to improve the employee working condition, or making sure that everything is like giving those whatever is like statutory requirement, right? So they are like facilitators, not a kind of a what you can say that there isn't a cop kind of thing. So they are like facilitators to each and everyone, so that it is like a smooth process for employees as well as employers.
So, I also want to add a couple of pointers here. So, as Thirupathi mentioned that, inspectors are going to be more of a facilitators. If you look at the developed economies, and specifically, I would take an example of Australia. Australia is a very classic example from where I think India also works closely with them, wherein regulators are always working like a facilitator. Okay, if they see a non-compliance, they don't go and start penalizing you, but they will also sit down with you and devise a plan so that you can be a better compliant, where it may mean organizing some training programs, so you are recommending some processes or some firms who could help you in getting yourself better compliant. Now, I think and and why I'm saying this is important to understand, because the way we look at compliances today and the way we will look at compliance in the years to come, I think that entire perspective is going to change. From a time and I'm saying, just think about it. Okay. uh, just very common example, I have to say, take when we were on the we used to drive on the roads maybe 5 years back, when we only knew that, sorry, I'm going to use a couple of Hindi words, but when नाके पे पुलिस खड़ी होगी, then I know I will have to slow down, or I would have to follow that traffic signal. But today there are cameras all over. Even if it's midnight, I can still be fined if I even if I'm driving at a speed which is not allowed on that particular lane. And people have been getting, because there are cameras, there are high resolution cameras. So you get careful everywhere. So what happens is you change your perspective, you bring a change in the way you work and you react. And slowly we are seeing that we are getting more aligned in our lane drivings, in our speed limits and all. We're getting more subconsciously also more aligned to it. Same thing is going to happen in your compliances also. While this change has, with companies like 2013, it came into Companies Act, with GST in taxation, with the labor code is going to bring this change here. And another important reason, India is talking about being a 25 trillion economy, 10 trillion, and the roadmap is set for 2050. If you have to be such a I would say the world's leading economy, and the growing, not from a growing to a from a developing to a developed economy, we need to build more cities. When you have to have to build more cities, you need more manpower and organized manpower. If you need it, you need to bring parity, so that people don't start running to tier one cities today. If from tier two city, from place like Jaipur, if somebody wants to go to Bangalore, or somebody wants to go to Bombay, because you're getting a better pay in that place. If we start getting it similar pay pack levels, and a better manpower in every state, every tier two and three cities, the manpower crunch will become lower, the burden on the top cities will reduce, and as a country, we would be able to contribute more and grow more. I think these some of these important aspects one has to really understand, and not just put into what compliance I have to do, but understand from our complete approach towards compliance. Sorry, Urvati, I just intervened in this,
No,
but
no, that's fine.
yeah, yeah.
And one more thing, so I just want to add to that one. See, previously, as you mentioned, that whenever we see police or someone, right, so we'll afraid of, because if you see the labor, which is the new code, it's not asking you to get those kind of fear. So you can approach them and try to get the issues resolved from their side. So that's what it's like if you see, the government is also introducing friendly police. So the same thing here, we are trying to accommodate in that way, stating that okay, so we are trying to help you, so that working conditions of the employees also improving, and ease of business, which is again priority. If you want to increase our growth of the economy, so you should also give that doing business simple way. So instead of like complicating all other stuff, so we are like simplifying it. So that's what the major focus in enacting this kind of wages codes, I can say.
Right.
Next.
Yeah. So I'll take up the following slides, and thank you, Mr. Reddy, for giving a very informative session on the earlier slides. Just to briefly explain, okay, so every legislation or every act has certain rules under it. And if you look at the objective of the labor codes, the primary objective of the codes were to have uniform laws across India. Therefore, the main purpose of introducing these codes were to ensure that the laws are uniform. And this was especially quite beneficial for large organizations having offices across India. Now, the procedural aspect is something which is dealt under the rules, which is, of course, also contemplated to be introduced as part of the labor codes. Now, I'll tell you what the ambiguity is. And I'm not saying it's an ambiguity, but as of now, most of the states have published their rules. But of course, as of now, nothing has been notified. It's only at publishing stage. There are only a couple of states and union territories that still are required to publish their rules. States like Meghalaya, Nagaland, West Bengal has still not come up with their rules. And from union territory perspective, it's the other Nagar Haveli, Daman and Diu and Lakshadweep. They are also still required to come up with their rules. So with respect to each state specific rules, the point which everyone is looking at that how uniform these would be, because as of now, state rules are quite different. The procedures across states are different. Even the compliance are different. Now, with the objective to ensure uniformity and in order to ensure that the purpose of introducing labor codes is not diluted, the biggest challenge to see would be how aligned are these rules and processes across states. As of now, we have gone through a couple of state rules. I would say most of the rules are quite aligned with each other, but some of the rules are different. Some of the procedures are different. So this is the biggest challenge what one may face and one may have to look into once all the state rules are notified. Moving on to the next slide. So now I'll be discussing certain key definitions. One of the major definition is the definition of employer, because earlier, if you look at the labor legislations, there were approximately some 60 odd labor legislations, then there were rules, then there were state specific legislations, and the definition were different under each of the legislation, under most of the legislations. Now, to ensure that there is uniformity, the labor codes have also come up with uniform definitions. And one of the major definition is the key definition of employer. Now, if you look at the definition of employer, they have tried to deliberate upon employer from a factory perspective, from a commercial establishment perspective. And some of the definition is primarily occupier, manager of the factory is the employer, authority manager is the employer, legal representative is also the employer. Government at all levels would be considered as employer, and the contractor would also be considered as an employer. So this is the key definition of employer, and now it will be a unified definition across the codes.
So Vaibhav, if I may ask you, how does this change the perspective about about compliance?
Okay, so from a compliance perspective, and I won't say this will change from a compliance perspective, but I will tell you this will change entirely from the perspective of penalties, because earlier, so in case there is a contravention, in case there is a violation under law, who would be held responsible? So that is most critical, who the employer is. Whether an employer is someone who manages or controls the organization, or from a factory perspective, when you apply for a factory license, you need to specify who's the occupier of the factory. So now these labor codes have made it very clear who would be responsible in case of a non-compliance. It will be the employer, and for employer, if it's a factory, you need to get hold of the occupier or manager as notified under the license, factory license. If it's for a commercial establishment, it will be a manager or a managing director.
So what I understand is like what I've seen the practice today, that when I'm applying for a factory license, I would normally give a name of not the director, but maybe a factory head or some employee as a occupier or manager for the particular factory. So as per the new definition, if there's a non-compliance, he or she may directly be held responsible in this case as well, right?
Absolutely.
Okay.
If you see the previous, maybe, sorry to stop you, Vaibhav, here. Yeah, see, if you see the employer version, right? So if you see the code, the latest code, and they have included many other factors also, because previously only some of like scheduled employments are there as an employer kind of thing. Now the wide coverage also there for all other, for example, contractors that they used to escape from the penalties and other stuff what Vaibhav mentioned, right? So those kind of escapism or maybe running away with those kind of things is like limited we cannot say that nothing is like 100% everywhere. So there will be a scope for gap everywhere. But yeah, I think this is trying to cover wide coverage for all the employers to making sure that aligned with making sure that all other codes.
Right. Thank you.
Now, the next key definition, let's move on to the next slide. The next key definition is the definition of appropriate government. And this essentially denotes which government authority would have jurisdiction over a particular establishment that is covered under the wage code. Under the code, the central government is the appropriate government. So it's quite self-explanatory. For central government, railways, mines, oil fields, major ports, telecom industry, whether it's a privately held or not privately held, the appropriate government would be the central government. But all organizations that are owned by state government, for them, it would be the state government, the appropriate government, or any other private establishment which has not been set out under these heads, which has been listed, which is as part of the PPT, would the state government would be the government of the appropriate, having appropriate jurisdiction. Let's move to the next slide. Okay, so under the next slide, and this is a key slide for every one of us, this talks about a difference between employee and worker. Now, if you look at the code, in some instances, they have used the word employee. In some instances, they have used the word worker. So the code prescribed two separate definitions of employees and workers. And if you look at the slide also specifically sets out who an employee is. Primarily, an employee is person employed on wages to do any skilled, semi-skilled, unskilled, manual, managerial, administrative, supervisory role. Includes a person declared to be an employee by the appropriate government, but does not include armed forces of the union apprentices. On the other hand, worker includes any person other than an apprentice employed in any industry to do any manual, skilled, operational, clerical, supervisory work. It also includes person doing supervisory work whose monthly salary exceeds 15,000. So supervisors whose monthly salary exceeds 15,000 are not included in the definition of worker. While if you look at the definition of employee, it includes supervisory, managerial, administrative roles, irrespective of the salaries they draw. So employee is the umbrella definition, and worker is a subset of employee. And if you look at the definition of worker, I'm sure everyone would recall that this definition is akin to the definition of workman, as has been explained under the Industrial Disputes Act. Now, the biggest challenge, or I wouldn't say challenge, but yeah, one of the analysis which everyone would need to do is whether your workforce is workmen or non-workmen, or workmen or employee. It's similar to our earlier analysis under the Industrial Disputes Act. This will also be a fact-based analysis. One needs to look at the roles and responsibilities enjoyed by each of the employees to understand whether a person is an employee or a worker or similar to workman, non-workman. Another challenge is given the fact that when these codes are introduced, we would not have much jurisprudence around it. We expect government to come up with clarifications, but in terms of reliance on jurisprudence, I'm sure to an extent we can rely on earlier case laws, earlier judicial precedents that have been pronounced by several courts, including Supreme Court, high courts of various states, just to ensure that what principles need to be applied while assessing or while analyzing whether a person is an employee, worker, non-worker. So this is something which one need to ensure.
It's better for an organization, would you want to throw some light as to, whether these change definition will impact any industry or specifically maybe manufacturing or trading or IT, mines, any?
No, look, Jyant, this is very similar to the workman and non-workman analysis as we do under the Industrial Disputes Act. To my understanding, this will be applicable or this will impact all organizations irrespective of the nature of business they conduct. Whether it's mining, manufacturing, commercial establishment, IT, ITES, it's quite similar as we do the analysis as of today also. So from a workman, non-workman perspective as well, there is no difference whether the individual is working in a factory or an individual is working in an IT company. We usually see what role and responsibility each one of them is basically enjoying. If a person has some kind of a reporting role wherein a lot of people report into him, he can take important decisions on behalf of the company. He will be considered as a non-workman. All on the other hand, if a person as a designation, he holds a designation of a vice president, but there is no one who's reporting into him. He doesn't take important decisions on about the company. He doesn't have signing authority. He can't fire anyone or take important decisions. He's an individual contributor. So he will be considered as a workman under law. And there are several case laws to support this. So this will be quite similar to the current analysis that we do for workmen and non-workmen.
Okay, thank you. Yeah,
So
sure.
we can move to the next slide. And now I think Mr. Reddy will take over these slides.
Yeah, thank you, Vaibhav. I think so. Everyone is like more looking into what is wages actually. So it is impacting all the employees as well as employers and whoever is like involved in the work environment. Right? Those are like impacted with this definition. So if you see the definition as per the code, so it includes all remuneration, whether by way of salaries, allowances, or otherwise, if the terms of employment. If you see the line, right? So there are two things are there. One is what should be included in the wages, what are not included in the wages. So what is included in the wages is look basic pay, dearness allowance, and returning allowance if you are providing anything to the employee. All these things are considered only for the calculation of wages. Whatever, if you see other things which are not included in these wages are bonus payable, house rent accommodation, as well as house rent allowance, which we are giving as part of our allowance process. PF contribution, which is paid by the employer, and conveyance allowances, overtime allowances, any commission or sales commission kind of stuff, and gratuity and retrenchment compensation, and for any award or settlement which we are giving as a remuneration, and if you are giving as any special allowance. So those are not included in the wages as per the code. So where there is like total exclusions exceeds 50% of total remuneration, so those excess amount should be added back to the wages. So that kind of scenario I'll going to give in the next slide, where we are talking about so what is actually considered for the 50% of wages and what is not considered for 50% of wages. So if you see, I have taken the two scenarios where like it's a simple scenario. So I'm not going to the detail about what exactly other details, how we are calculated PF and overtime other stuff. So I'll talk about only basic dearness allowance, which is part of wages. If you see in the first scenario, the total remuneration is 50% or 50,000. So if you take as per the code, 50% of that total remuneration is 25,000. So that is comes under a basic salary and dearness allowance. So if you take those things, 25,000. So remaining 25,000 can be part of allowances which company is providing to you. It can be house rent allowances, bonus, conveyance, sales commission. If you see PF employer is also part of that. So there is no inclusions or anything in that one. If you see second scenario, where if you see total remuneration is 71,500. If you divide it by that two, it is coming around 35,750. If you see basic salary or dearness allowances, it is showing only 25,000. So normally what we need to consider there, so it's see what kind of because if you see as per the code, so there should be 50% of allowances should not exceed. So if you see here, house rent allowance 6,000, bonus 3,000, conveyance 3,000, 26,000, almost like all these considered should not be should. If you see if the total percent 50% that is 35,750 is hello.
Yeah,
Is it
yeah,
okay?
yeah,
So,
yeah.
okay.
We can
So
hear
if
you.
it is that is more than that, So it should be added back to your basic and dearness. So that's how you have to change it. So if your current structure is showing that only it is not showing as 50%, so you should make sure that your basic and dearness allowance should be coming under 50% and remaining allowances should be 50%. So in that case, what is happening? So if you are not keeping employer as a PF employer is like not ceiling like 15,000, in that case, it is showing as 8,800. Otherwise, your net take home will go down drastically because your normally we are not giving 50% on your basic and DA. So now if you are giving in that way, your PF will go. See here why they are doing the changes. We have to understand two things here. As a private part of uh, organization, so we don't focus on our social security. So after retirement, right? So you don't even get anything in your pocket. So that's what the major focus in creating this kind of structure where basic DA is like more than 50% and our social security is increasing to that level. Okay, and one more thing here, they've added like in-kind payment, for example, canteen subsidy. So if some companies are providing canteen subsidy and free transport, so those are if it is those are exceeding 15%, so those are not included in your wages. If those are not exceeding 15%, so it should be added back to your wages. So technically, for example, 25,000 is your basic DA, and if you are providing transport, for example, 500. Okay, so it is not your 15% of your salary. So in that case, it should be added back to your basic and DA so that you are keeping that to 50% of your basic. Okay, and one more thing. So here there is a drawback in the code. Maybe it is my version. So they mentioned that 15% of those kind of the in-kind payments, but there is no definition how to calculate that one because people can create that transport. Some people will say that 500 can be 600. So those are the stuff. It might go to 15% and it's less than 50%. So they are trying to do that kind of a elimination process so that they can take that. That is the drawback of this code. Maybe I can say that in-kind payments is a version where you have to focus more in terms of changing that so that it will give priority to all the employees.
So what you're saying is that today, from a tax saving perspective, if companies are trying to break it into many headers, which would be from, which could be put into reimbursements for that matter, that is something which organization may end up doing away with, or they will have to reconsider all that.
See, any company, if you see in the current scenario, we are trying to give more than the more allowances. So that's what we can focus on reducing our income tax. But in the longer perspective, once it is enacted, like so your income tax components are reducing. If you see, because house rent allowance previously we used to give more, and that is again reducing from your CTC. For example, 1 lakh salary employee. So previously basic was like little less, and they are trying to give more into HRA. So now basic and DA is coming into 50,000. So those 50,000 going into not into allowances, right? Only 50,000 you have to focus on the allowances. In this 50,000 you can give it as a conveyance
50%.
or any other things. Yeah, sorry, 50%. I've given example of 1 lakh. So 50,000 is like, so you are trying to give only allowances of pertaining to those 50,000. Okay, so that way I think income tax is like we have to pay more income tax in terms of providing that to the government. But if you are trying to save on other factors like ATC, ATD, all other things, if you are focusing, right, that may you can trying to reduce, because major focus of this code implementation is providing all the social security to each and every employee in India. So that's what the major focus. So that's why they are, because if you see companies, PF employer, they are trying to get it away from that fund. So now maybe if you are giving all those stuff, right, they cannot even run away with that one. Okay, in example, I think someone is asking, in example of PF employer 6,000. So I have taken 12% and 25,000. So that's why coming it to that kind of thing. So that is a rough estimation. So don't consider that as an amount, because that's what I told you. So I was only focusing on basic DA and total remuneration. So I didn't calculate all other things in the factor, because our focus only on the wages. So which is again 50% of wages should be part of your allowances should not cross 50,000. So that's how I maintained here in this slide.
So, Vaibhav, I just want to hear your thoughts on this slide.
Okay, so primarily I'll tell you the reason why I feel the government has come up with this ceiling of 50%. Because historically, for tax benefit purpose, as Jayant and Mr. Reddy has also pointed out, organizations usually they used to bifurcate the salary into various components purely from the perspective of saving tax. Now, the biggest impact used to be on the definition of wages, that what needs to be included under wages and what needs to be excluded. The definition of wages were also different under certain labor legislations. Now, the Code on Wages will also unify the definition of wage. Secondly, the biggest reason why they have done this 50% capping is to do away with all these several allowances that are being paid. And also, I'm sure everyone remembers the Provident Fund, the famous Provident Fund judgment, under which it was clarified that what needs to be included and excluded as part of wages when you're calculating PF contribution. Now, this will also take care of those ambiguity which everyone had, and it's very clear. So if whatever is more than 50% of the wages will be included as part of the wages, and accordingly you need to make contribution, whether it's a PF contribution, ESI contribution, gratuity, leave in cash, or sorry, leave encashment is on gross, but all of this will be tied up with the definition of wages, which now is quite self-explanatory. Yeah, so these are some of my thoughts on this.
So, one more, a particular component is here is sales commissions. Now, sales commissions usually is, in so many companies is part of your variable package. So this also falls under the overall computation of wages.
Yes, so
So look, it need
that's okay. Go ahead, Vaibhav. Yeah.
Yeah, so as Mr. Reddy said, it will be included as part of the wages, but one also need to, I think Mr. Reddy, you were saying this, right?
Yes. You go ahead.
Yeah.
I will add my
Okay.
version because there are.
Okay.
Yeah.
So one also need to examine that what kind of sales commission is it? Is it just a component and it's a fixed commission which is payable every month on a monthly basis, or is it actually a sales commission which is conditional upon achieving a sales target? So if it's just a component that has been introduced as sales commission, which is fixed, not dependent on any sales target, it will be included as part of wages. But if it's a proper sales commission, which is conditional upon an employee achieving a sales target, and if he doesn't achieve, he will not be paid this kind of a sales commission, then I think we may have an argument to exclude it from the definition of wages.
Yeah.
And it may, sorry, Weber, there's one follow-up question. So this may also include annual performance bonuses, which company usually give to the non-sales employees.
If it's an
Because
actual
today,
bonus, and if it's an actual bonus similar to as I explained for sales commission, then I think this principle will also apply
okay,
with respect to performance bonus.
okay.
Yeah, same thing here. Because see, if you are showing it as a regular or monthly component, so in that case, it should be included in that one. Because normally, some companies or majority of the companies, they will show that if you achieve this kind of target, so you will get this kind of a sales commission or this percent of sales commission. So those cases when it is again pertaining to those kind of things, right? For example, normally sales commission is quarterly or yearly payable. So those kind of stuff, I think you are not paying as a regular or monthly component. So that cannot be added to the
Okay. I think that this helps. Great. Yeah, Akshit, let's move next.
Okay, if you see the different difference between the previous Minimum Wages Act 1948 to the current one, so if you see there are like scheduled employments were eliminated in the current wages. So there is a wider coverage. So they are including all other because technically they are eliminating the scheduled payment concept itself, scheduled employment concept. So trying to include wider coverage for all the employees, all the establishments are companies. When Vaibhav mentioned about the employers, right? So if you see that there are like so many other criteria also included to cover that employer. Coming back to the wages, which is a major change, I can say that previously we used to include HRA as part of our wages. Now HRA is not included in the inclusion; it is like part of exclusion. So we're showing as an allowance. And there is one more change in the wages, which is like in-kind payments to 15 percentage. So that is again, so if you are less than 15 percentage, it is part of your total wages. If it is more than 15 percentage, it no need to include in the total wages. So if you see the rest day and normal working hours, so I think previously each state has their own kind of thing. Right now, if you see the central as per the previous 1948 minimum wages, so central rule states that 9 hours as a normal working hours. So and one weekly rest day. If you see that in the current code, it is only 8 hours is like working hours and one is a rest hour for each day. So if you are working for 9 hours, then one rest hour is mandatorily should be given to the employee or worker. And other things, overtime wages. So if you see the overtime wages, there is no much change as per that one. But only thing is like, see, previously it was only limited to scheduled establishments or employments. Now, so all other casual workers also included to this one. And overtime is like, again, when Vaibhav was explaining for the one of the senior person, right? So those people also trying to include in that one. For example, casual workers were also part of those kind of the overtime coverage. And if you see minimum wages, previously minimum wages was like there are like each state has their own minimum wages as per the current wage, right? Current wage code, and there is a national floor wage, so which is determined by the central government. So whatever main minimum wage which you are giving, it should be more than that. And the criteria for defining that minimum wage is again skill set and geography. So when I say skill set, so there are four types of skill sets are there: skilled, unskilled, semi-skilled, and highly skilled workers. And again, each geography, metropolitan, non-metropolitan, so although based on all other working environment conditions considering and taking those as a floor wages. And after that, when any state is defining as their for own minimum wages, it should be more than that. So technically, for example, if you are giving minimum wages, and floor wages 100 rupees or 179 as per the national current one, 179 rupees per day. So whatever we are fixing for minimum wages now, it should be more than 179. Or if you are keeping 179, that is again holds good. And if you see currently, if your minimum wage is more than that, you should not reduce that to the floor wages. It should be when if you are keeping it 185 example, so it should be the same manner. So previously there is no such concept of floor wages. So now that is additionally giving that control for floor wages from by the central government. And if you see the revision of minimum wages, I think there is no change in that one. For each 5 years of interval, it should be revised so that we are meeting all the inflation and all other living standards of the employees. Yeah, I think moving back.
Maybe I also want to hear Vaibhav's thought on one of the concept here. National floor wages, Vaibhav, you want to throw some more light on this? What do you expect from this?
Look, while ascertaining the floor wage, right, there are a couple of factors which the government will also look into, and the biggest factor is standard of living, because standard of living in each of the state is different. If someone is living in Delhi, Bombay, in Delhi as opposed to Bombay, Bombay is much more expensive. So I'm sure the minimum, the national minimum wage or the floor wage that will be set will uh will the government will assess all these aspects, and after which only they will ascertain the floor wage. And now, after that, the states would be given the power to set the minimum wage as applicable in their particular state. And as Mr. Reddy has also pointed out, the state minimum wage or the state-wise minimum wage that will be introduced can't be below the national minimum wage, but of course it can be more. And also, if the existing minimum wage as set out or as introduced by the states are more than the national minimum wage, then they can't reduce it. Then they can't reduce it.
Okay, so you have to follow whatever is higher. Obviously, you have to follow
Yes,
what the state says, and state cannot set anything lower than the national floor rate.
absolutely, absolutely. And if the current minimum wage set by the state is more than the national minimum wage, it's not that the state can take advantage and further reduce the minimum wage.
Okay. So I think this takes me back to what I was talking. So at least a government wants a level playing field for everyone across the country. At least because you go to certain particular states and you see wage levels uh, extremely low, and if you go to remotest location, then you will see uh, at times minimum wages are not even a concept which they would understand. So let's hope this brings some bit of a
Absolutely.
parity across the country. Uh, and specifically, I think if you are, for anybody who is into manufacturing and you have remote manufacturing location, and I've seen a couple of industries, specifically, I would want to say, maybe a textile, and where you are, operating in remotest of the locations. I think if you're into those industries, I think this something which a concept which you need to be more watchful about, more careful about, because this will impact. This will have a lot of impact in your business as well. Yeah, thanks, Mr. Reddy. Thanks, Vaibhav. Akshit, let's move next.
So we can move to the next slide, which is on payment of wages. So as opposed to Payment of Wages Act, which is the current legislation and that will be subsumed into code on wages, the wage code cover all establishment except government establishments, and it is pertinent to note if a chapter on payment of wages under the wage code is not applicable to government establishments in entirety. The wage code also does not prescribe any threshold because in the current Payment of Wages Act, the threshold is 24,000. The Payment of Wages Act is only applicable to employees earning less than 24,000. However, under the wage code, there is no such coverage regarding the chapter on payment of wages. So it will be interesting to watch whether the state will come up with their own thresholds or whether there will be no thresholds. There is a possibility that there may be no thresholds. As regards deductions on accounts of fines, absence from duty, damage, under the existing legislation, the permissible deduction ranges from 50 to 75%. However, under the code, the amount of deductions made under any wage period have been unified and shall not exceed 50% of the wages. In case where the authorized deduction exceed 50%, the excess shall be carried forward and recovered from the wages of succeeding wage period. As regards the time frame for payment of wages and permissible deductions, there have been various developments. The timeline for payment under the existing legislation is either before or expiry of 7th or 10th working day. This depends on the total head count from the last wage period. But as you can see from the table here under the wage code, the deadline depends on the nature of engagement. That is whether employees are engaged on a daily basis, weekly basis, fortnightly basis, or on a monthly basis. There is also an obligation on the employer concerning payment of wages to the contractors. So establishments are now under the establishments under the wage code are required to pay contractors before the 7th of every month so that the contractors can further make the payment to the contract workers. This is an additional obligation that is not there under the existing legislation. Additionally, in case of a default by a contractor in making any maybe statutory bonus to its contract labor, the employer shall be responsible, which is the principal employer, for making such payment to such contract workers in case the contractor fails. We can move to the next slide, which talks about bonuses. So the current legislation about bonus is the Payment of Bonus Act, and it's quite evident that it's only applicable to employees earning more than 21,000 are not entitled to statutory bonus. The wage code also similarly states that the government will set a salary threshold to determine the eligibility for bonus. Currently, the salary threshold of 21,000 is applicable across India, but now the state government has been given power to set the eligibility criteria for bonus. So there could be a possibility that there may be different salary thresholds depending upon the state in which the employee is located. This is a very important and significant difference. However, the wage code further specifies that employees earning salary that exceed this threshold will also be entitled to bonus. However, for calculating the bonus, their salary will either be counted as the designated salary threshold or the applicable minimum wages, whichever is higher. So it's not that only employees earning less than that threshold will be entitled for bonus. Even employees earning more than that will be entitled for bonus, but salary will be considered either the minimum salary or the salary threshold set by the government. So this is a additional financial outlay or financial impact on the organization, because now there is a possibility that everyone will be entitled to receive statutory bonus. The wage code also now requires employees to pay bonus for by crediting it in an employee's bank account. Earlier, it used to say only cash. The minimum rate of bonus payable under the wage code is 8.33% of the wage or 100 rupees, whichever is higher. However, the wage code requires an employer to pay a higher amount of bonus in case the employer has any excess allocable surplus.
So what do you,
The wage
what do
code
you mean by?
also,
Sorry, Weber, you
sorry.
cover, and you please cover it, then I'll come back to my questions.
Yeah, the wage code also specifies how to calculate available surplus, which is the employer's gross profit minus certain deductions, like 60% in case of banking companies, 67% in case of other establishments. Of the available surplus forms the allocable surplus, and all of the allocable surplus need to be paid out as bonus. So just to give you an example, if the company has 5 employees with a salary of 10,000, so it will be 8.33% of 10,000. Then we need to assess what is the minimum allocable surplus, which the employer must have, which is primarily 8.33% of 10,000, which is 833. Considering they have 5 employees, then it will be 833 rupees into 5, which comes out to be around 4,000 rupees. Now, if the allocable surplus in a year is 6,000 rupees, then this entire amount needs to be now divided in proportion to the salary earned by each employee, thereby resulting in a higher bonus amount. And yeah, and bonus is also capped at 20% of the salary. So irrespective of the allocable surplus, an employee will not be entitled to receive more than 20% of his salary as bonus. Sorry, Jyant, you were saying something.
Yeah, so allocable surplus, how do you define it?
So allocable surplus, as I explained to you, basically first you need to look at what is the available surplus. And available surplus is the employer's gross profit minus there are certain deductions contemplated under legislation. Then from that available surplus, available surplus then forms part of the allocable surplus. And allocable surplus basically is calculated based on the number of employees, their salary, and their minimum bonus that is payable to them. So minimum bonus is 8.33% of the all employees are earning 10,000 rupees. So 8.33% of 10,000 rupees will be 833 rupees. The minimum allocable surplus will be 833 into 5 because there are total 5 employees. So 4,000 rupees will be the allocable surplus.
Okay.
And
sorry,
and so yeah, so this is how you will assess allocable surplus, and whatever the allocable surplus is, then that needs to be divided proportionate to the salary earned by each employee. And there is an upper cap of 20%. That 20% of the salary will not be bonus.
Okay.
And okay. Going forward, another important development is that now wage code also includes sexual harassment as a ground for disqualification from receiving statutory bonus, which was not there earlier.
Okay.
Moving on to the next slide, which is on equal remuneration. So with regard to discrimination in matters relating to work, the wage code has now expanded upon the grounds on which discrimination is prohibited. Earlier, discrimination was prohibited in matters of recruitment, transfer, promotion. Under the wage code, discrimination is prohibited regarding conditions of employment, which is a very wider term. So conditions of employment would include everything. The wage code has also introduced a fresh parameter for determining if two persons are conducting work of the same or similar nature. Equal remuneration only talks about skill effort responsibility for determining same work or work of similar nature. Now, wage code also includes experience. So I and you may have the same skill set, but experience is also something which one needs to look at. I may come up with 10 years of experience and you may be coming with 15 years of experience. So accordingly, if you are getting more salary, a discrimination claim may not be valid. As you can also see, the Equal Remuneration Act has a fairly ambiguous and wide definition of the term remuneration. However, the definition of wages is fairly limited under the wage code, given that it only includes three components. So that is also a respite from a definition of remuneration to now a definition of wages. Another important slide, we can move to the next one, which talks about the employer's obligation. Wage code has also reduced the compliance burden, and that is like, as both of you have also mentioned, that the biggest reason for introducing labor codes was ease of doing business in India to attract more foreign investment. And like no one is happy uh, following or undertaking several compliances. So now the wage code has also reduced the compliance burden on the employer. For instance, by requiring only two registers to be maintained and one annual return to be filed, as opposed to the current legislations which have been subsumed under the wage code. There are duplication of registers that needs to be maintained under payment of wages as well as payment of bonus as well as Shops and Establishments Act. So now everything will be unified. Uh, so these employer obligations, it's quite self-explanatory. Maintenance of registers, it will be unified. Display of notices under each of the legislations where there were different notice requirements. Now everything is unified. Of course, payment of wages, as we discussed, it will be within the prescribed timelines. There will be time limits for working hours, rest days. There's a requirement to issue wage slip. So these are certain employer obligations which are worth looking at. I think let's move to the, yeah, so this brings us to the end of the presentation, and we are happy to take any questions which you have. And there are certain questions which I think Jyant would be taking up.
Sure. I think this is a common question. I've received many messages since morning as to when we can expect the codes to be implemented. I think I have, discussed it in the beginning itself. Um, I think a lot depends on the political landscape, how the next elections results will be, how the state governments are aligned. I think a lot would depend on that. But if all goes, I think from an organization's perspective, we should be prepared if it comes in immediately after the next election, because uh, those are things which one has to be ready with. And again, this is a 2019 code, still in waiting. No confirmed date. Whether you want to
Absolutely,
give us.
Jayant. No, I echo your thoughts on the implementation of the codes, and most likely, like in all likelihood, it will be implemented only after the general elections, which is scheduled in April 2024. But as Jayant also rightly pointed out, that one could prepare itself before the implementation. And given the fact that in most of the organizations, March and April is the month wherein salaries are increased or there is an increment, maybe you can take advantage of that situation and align your compensation structure with the definition of wage. While I don't want to say that the definition of wage may be as it is, there is a possibility that there could be certain changes in the way definition of wage. The possibility cannot be ruled out, but one could explore thinking about these aspects, that while you are planning to roll out the revised compensation, you may also reconsider looking at the bifurcations and the different heads which form part of the compensation to align it with the definition of wage, just to see whether financially there is a huge impact on the organization, because with the change in the definition of wage, your PF contributions, social security contributions, everything will be impacted.
Okay, thank you. Fixation of wage ceiling for bonus, whether different state governments would prescribe different limits for bonus calculations and eligibility. Um, Vaibhav, your thought?
Look, honestly speaking, I would expect all state governments to be aligned. Otherwise, the main essence or main objective of the code to rationalize everything and simplify the labor law regime will be diluted. But like it's a vote bank, right? So you can't predict anything. But I don't want to completely rule out that the bonus limits may be aligned across states.
The next, Mr. Reddy, next question, I see this from Mr. Balram Nandi. The question, I'll just come on to this, Akshat. What are pay head to be heads to be considered to calculate leave wages, current law versus wage code? As of current, should we calculate on gross in case of employee in shops and establishment?
Hello.
Yeah,
Are you talking to me? Okay.
yeah.
Okay. Can you repeat that question once again? Sorry,
What
I think I missed it.
what are the pay heads to be considered to calculate leave wages under the current laws, and what is expected under the wage code?
So, I think there is again still ambiguity is there in that, as Vaibhav is mentioned previously. I think I will suggest Vaibhav to take this question on that one, because I still feel that because the people in the current one, right? For example, if you take Maharashtra, because which the people are talking about here, Maharashtra state, that one, right? So they are only total wages is considered for the leave wages. So that's what they are considering it. But if you take the
So
new wage code, yeah.
sorry to interject, but if you
Please.
look at the existing Shops and Establishments Act, I think like this is the view what we have taken, and it's coming out of the Shops and Establishments Act that leave encashment need to be on gross salary.
Correct.
Now, if you look at the wage code, I don't think the definition or the calculation of leave encashment would depend on the definition of wages under the wage code. The reason is none of the Shops and Establishments Act is being subsumed under the codes. So Shops Establishment Act is a separate legislation which also sets out certain condition of service, one being leaves and other being leave encashment. So in my view, unless the government come up with certain clarification or maybe with the intention of subsuming the Shops and Establishments Act, I think like leave encashment needs to be calculated on gross salary.
Okay. Akshit, let's move next. Yeah. What are the timelines? I think this is something which we covered. Um, Unless we are talking about FNF, which is one of the questions. If Vaibhav, Tirupati want to
So
take a.
I'll take up. So if you look at the Payment of Wages Act, it's specifically specifies that the full and final needs to be made before expiry of the second working day from the date of termination of employment. This time limit is applicable in case of termination, closure of establishment, but unfortunately, or there's an ambiguity, it's not applicable when the employee resigns. Now, if you look at the wage code, the time limit has been same, which is 2 days, but now it also covers resignation cases. So technically under the wage code, irrespective of the manner of exit, whether it's termination, closure, or resignation, the time limit has been set, which is 2 days from the last date.
Okay. I think
And
that's
one more thing to that one. See, those only talking about wages, correct, Vaibhav? So if you see gratuity and other things, right? So those again, previously we are paid within a month or something. So now, so if you see that one, so that is also, for example, any resignation. So if he is like trying to resign within, we spend 5 years or 6 years, he is eligible for gratuity, and is resigning and is serving full notice period and all other things completed. So gratuity still those 2 days he has to pay that, getting paid those within 2 days are the same with the 30 days. So that's what my understanding is, wages will be completed within 2 days, and gratuity and other which are like not part of wages can be paid after 30 days.
Yeah,
okay.
I also have a similar view.
Incorrect. Because majorly focusing about the settlement of wages, those are wages which we are talking, right? Those things should be settled within 2 days.
Right. Great. Akshit, any further questions? Okay, I think this brings us to the closure of discussion. Uh, one Ankita has just shared one link on the chat box. Um, as you're seeing, there is an article on our website which which keeps a track of all the rules which are notified under all the four codes. You could you could keep a track of whatever is changing from that link, and I think that will be quite helpful. And we would there are a couple of pointers I think which came out of the discussion today. We would try and add those pointers to our existing articles as well, because these are quite helpful for everyone. And we'll post them on our portal as well. And Vaibhav, thank you so much for your time today. And over the last 15 days, and in getting this deck prepared and discussing your thought process with the team as to how we need to put this across together. And I look forward to more interactions coming from you, because this is just a big beginning of the code, and I think if it is implemented in years to come, I think there is a lot more questions, queries which will come from the industry, and I think we all should be ready to address that. Thank you so much,
Sure.
Thirupathi, for your time, and it was a pleasure having you here. And again, as I said, Vaibhav, I think will look forward to your detailed understanding about the key components. How on the ground, because I am seeing there are many questions coming from, and I think we'll have more such questions on each component, because this is going to create a lot of confusions in the minds as to because from having an absolute freedom of creating the salary structure the way we wanted to create, to getting it to a level wherein we have to be very sure as to what components and we can create. And I just want to share end up with with one of my experience of I used to be part of a company called ADP, which is into payroll services and compliance of payroll and compliance services, way before I founded Lawrbit. So we were sitting on one very large client. I do not want to name the company. It's a very old company, very large client in their own space, uh, into manufacturing, heavy manufacturing. So we were trying to get their payrolls, and they had around 50,000 employees, and we were trying to get their payroll outsourced to us. And while doing a business, understanding, we got to know that they had almost 250 salary components, approximately that. From having so many salary components, and our system could, we were struggling to figure out how do we map them all into our systems. I think gone was the days when we can be absolute flexible with those components. Look forward to many more interactions. Thank you again, Vaibhav. Any closing remarks from you, Vaibhav?
Nothing from my end. Thank you for being such a patient audience. Thank you, Jyant. Thank you, Mr. Reddy. Thank you, Jyant, for organizing this. Thank you to your team. And thank you, Mr. Reddy, for being an excellent co-host.
Mr. Reddy, anything, your closing remarks from your side?
Nothing from my side, because see, as you mentioned, so previously we used to have like many components. Maybe with this, I think there are so many other things can be reduced, so that like the external or foreign countries can invest in, and those compliances can be reduced, and employees will get the free of those kind of stuff, right? So because if you see any company, any components are not even understanding for layman, because freshers may not even understand. So now maybe those kind of things will give more clarity for freshers to understand what they are trying to get in the net take home. Yeah, and thank you everyone for joining the webinar, and thank you, Vaibhav, for discussing those critical topics which are like important for everyone. And thank you, everyone.
All right, thank you so much. Have a good
Thank you.
day and a good week ahead. Wish you a very happy New Year in
Thank you.
advance. Thank
Thank
you.
you.
Thank you, everyone. Bye. See you.
Bye.